All right, everyone. We're excited to have our panel today. My name is Will Trachman. I'm Associate General Counsel with the Mountain States Legal Foundation. We are very honored to have some distinguished guests today to talk about our topic, are Biden's agencies already captured by special interests? I'm going to talk briefly. I'll introduce our panelists. We'll go through their biographies. We'll open the floor. The question and answer box is actually already open. So if you have a question, we will be taking those from the public at about the 30 to 35 minute mark. We're excited to have not just our panelists, but also a robust number of attendees who probably have their own questions to ask our panelists. My name is Will Trachman. I served in the Department of Education before joining here as deputy. And our panelists today are first Jonathan Brightbill, who served as acting Assistant Attorney General in the Environment and Natural Resources Division at the United States Department of Justice. Professor Brightbill led the division's 425 lawyers. He was the lead environmental litigator and civil and criminal enforcement official for the United States, and is currently a professor of law at the university. Kent Holsinger, our next panel, is the founder and managing partner of Holsinger Law, LLC. Kent's emphasis is on lands, wildlife, and water law. His efforts have been recognized in the Wall Street Journal, the Washington Times, the New York Times, New Yorker, and on National Public Radio, among many others. Kent has helped draft legislation and has testified before Congress and the Colorado General Assembly many times. And third, our panelist, Kathleen Sgamma, is the president of the Western Energy Alliance. Prior to joining Western Energy Alliance, she spent 11 years in the information technology sector, managing the European consulting practice for a software vendor, and 3 years as a military intelligence officer in the U.S. Army. She holds a BS in political science, defense, and arms control studies from the Massachusetts Institute of Technology, and an MS in information technology from Virginia. As you can see, we are very fortunate to have such distinguished panelists with us here today to talk about whether President Biden's agencies already captured by special interests. So I'm just going to turn it over to the panel. Of course, you are welcome to not only respond to what I asked, but obviously what other panelists said. We want to make this open and free flowing to have a really great conversation. We are about a little over a month into the Biden administration, and I'd like to hear what your general thoughts and impressions are of President Biden's agencies, his appointments, perhaps what they've done so far. Very broadly, just what are your general impressions? And I will go ahead and start, I think, with Kent. Where do you think we are right now?
Thank you, Will. I think many of the things that we've seen early in the Biden administration have come as quite a surprise to me. I wasn't prepared for the activist radical agenda that we're seeing permeate nearly every part of the administration. And we're seeing, no surprise, many former Obama administration officials join. But I've been really taken with just how far they're going and how quickly.
Kathleen?
Well, I agree with Kent. I was hoping for a little more moderation because, if anything, the election results were totally moderate, really, up and down from Congress to even the presidency. I mean, Joe Biden was the moderate Democrat, right? But down to the state legislative level, really, it was a moderate election. The House is razor thin. The Senate is even more razor thin. So this is not a radical electorate. This is a very moderate electorate. Now, one thing I was not surprised about at all was that President Biden was going to go after federal leasing and perhaps permitting as well, but he chose to focus on federal leasing. We have been fully prepared for that ever since really before, but I mean, it was crystallized at the second debate when he said, oh yeah, we're going to frack because I need to win Pennsylvania. And I'm paraphrasing here, of course, but we're not going to ban fracking nationwide because I need to win Pennsylvania. But you know what? The West, I don't care about the West because, it's already baked in, which, there weren't really any swing states in the Western oil and gas producing states. And I'm really not going to lose any votes or any constituency if I ban leasing or permitting or fracking on federal lands. So we were fully prepared when he issued his ban on leasing, and that's why we sued within 5 minutes of that signature.
Jonathan?
Well, Will, thank you very much for the opportunity to be here with you today on the panel. And I would say that I am not surprised by much in terms of the actions, but they have moved with a tremendous amount of speed and without a lot of deliberation in a lot of areas that I must acknowledge that has moved more quickly than I expected that they would do. So, for example, one of the things that the Justice Department has done under the new administration is they sought to go in and stay various cases that were active that related to administrations of priorities of the last administration. And that's kind of, textbook change of administration type action by the Department of Justice. But some of the things that I was surprised to see them move so quickly on were one thing, the volume and the scope of the executive orders that we saw on the first day. Certainly people in the press have reported that that's unprecedented, but in particular because many of those executive orders, one questions the level of legal review and scrutiny that they either received or didn't receive by career and even new political officials from the Department of Justice, and whether and to what extent those reviews happened in the way that has occurred in past administrations. There have been a number of reforms that I think can fairly be characterized as good government reforms that were undertaken during the Trump administration at the DOJ. The prohibitions on payments to third parties who were not litigants in the case that could be used to create slush funds and special interest payouts and the like. That has been taken away, or action has been taken to take those away very quickly. Certain guidance that were issued to try to provide more due process, notice, explanation to regulated parties about how the Department of Justice will proceed in cases and make decisions. Some of those guidance and memoranda were taken down remarkably quickly and presumably without much in terms of internal deliberation and effort made to separate the baby from the bathwater. There's obviously an expectation that a new administration would want to change certain policies, but the degree and the speed by which they have moved away from all things that were associated with President Trump, because it was issued by President Trump's administration, I did find that a bit surprising.
Thank you for that, Jonathan. So there's a phenomenon called sue and settle, which I would love our panelists to weigh in on, both in terms of defining what it means and then talking about some of the concerns that you may have with regard to an agency that is sued and then settles with the person who sues them. Kent, do you want to start us off on that topic?
Sure, would be happy to. The Endangered Species Act is one of the premier examples of sue and settle. And there we see some strict timelines in the Act relative to when a species is petitioned for listing. There's a 90-day period, which if there's a positive finding, that triggers a 12-month review period. And what we've seen for a number of years is activist environmental groups petitioning to list not just the species, but hundreds and hundreds at a time. And then the agency that processes those petitions, the U.S. Fish and Wildlife Service, invariably they can't meet their timelines. And when they don't, well, guess what? The very groups that petition to list are filing suit under the Endangered Species Act. They're reaching a settlement with the U.S. Fish and Wildlife Service that comes with a new date often. And then they're collecting taxpayer-funded attorney fees and starting the vicious cycle over and over again. Back in the Obama administration, the U.S. Chamber did a really interesting analysis of sue and settle, and they followed about 71 cases that led to about 100 new regulations. And those new regulations led to an estimated $100 million annual economic impact. But what's really disturbing is the Chamber just scratched the surface. When you look at groups like Center for Biological Diversity and Wild Earth Guardians, we've tracked federal court records since 1990, and those groups have filed suit, we estimate, over 2,000 times, mostly against the Departments of Interior, the Department of Agriculture, the Forest Service. And that works out to a lawsuit more than once a week for the past 3 decades from these two entities alone.
Well, Kathleen?
Oh, I forget which one it is. I think it's CBD. I've got a great quote that I've put away that I pull out every once in a while. They're literally using species listings to end industrial civilization, i.e., the modern lifestyle that we have. Their founder actually admitted that. So it's not about protecting species. And, when Kent lays out the magnitude of this vicious cycle, what it does is it takes money away from actually recovering species and gives it to lawyers in environmental groups. So there's no environmental protection resulting from that. It's just listing species who linger on the endangered species list. And, there's a 2% recovery rate of species. So they're using fluffy animals because they know people like, the grizzly bear and the polar bear to be protected. But they're not actually protecting them. They're just listing, the dung beetle or the, hookless cactus or whatever. Not that some of those species also might deserve some protection, but you have species lingering on, and, it's taking millions of dollars away. And some species get on average maybe $20,000 a year to help their recovery efforts. So, it's not going to conservation.
Jonathan, do you want to talk more broadly about what sue and settle is and what your perspective on where it has been and where it's going?
Sure. Yeah. So sue and settle, it is an interesting problem, and it is one that is very difficult for the executive branch and the agencies to deal with, and it's one that continued to bedevil agencies even throughout the Trump administration, and in no small part because many of the problems that generate the sue and settle phenomenon are statutory in nature. There are these deadlines, and the agencies have the appropriations that they have from Congress. They have the staff that they have from Congress. And even when it comes to the Endangered Species Act, a lot of times, there will be specific earmarks as it relates to the amount of money that the agencies are permitted to spend doing listing versus other types of activities. And so invariably what happens is that the reality of Congress having legislated in the first instance a bunch of very stringent deadlines collides with the difficulty of Congress not providing funding support to the agency sufficient to meet all those deadlines. And the way the case law has developed is you have open and shut cases that are brought by the environmental groups and various of these entities against the agencies, saying that these mandatory deadlines, sometimes there are unreasonable delay lawsuits. It's another vehicle by which they occur, has been met. And one of the vices that you get caught up, and I'm speaking to you as a person who was caught in that vice, having had responsibility for defending those cases at the Justice Department the last several years, is then you also layer on top of that Congress has mandated attorney's fees. And so you find the agencies find themselves in the grip, and there is a certain level of bipartisan recognition that this is a problem, that the priorities, even of these environmental groups, are not necessarily and often aren't the priorities of the agencies and the career officials of the agencies who are there, whether they are with a Republican administration or a Democratic administration. There is a kind of a pernicious effect here of this litigation driving their priorities, moving resources away from where the best impact can be had from a species preservation or environmental protection and health benefit perspective. And the alternative is what? The alternative is to lose, and then have a schedule dictated by the federal courts. So one of the things that happened during the last administration, during the Trump administration, on the sue and sell front was kind of twofold, or there were three different things that were done, some formally, some less formal. On the formal side, there was an effort made by the agencies that are involved in this, or many of the agencies, to try to make sure that the public had more notice of these lawsuits when they come in, so that those parties with interests would have the opportunity to intervene and have their voices heard. Second of all, there was a recognition that I think early in what was identified as the sue and settle phenomenon, a lot of the settlements that were reached were settlements in terms of what these deadlines would be, were deadlines that were really very short and really jammed and forced the result that the plaintiff in the underlying suit was seeking to push. So they weren't literally settling for the result that the environmental group was seeking. They were merely settling, okay, here are the deadlines by which we're going to take an action. But for an administrative agency and the federal government to act, there's subject to the Administrative Procedures Act or other federal statutes that create a robust process and a time-consuming process. And so part of what having deadlines did was it sort of, put these policymaking efforts on kind of a one-way train towards the outcomes that were being sought, even if they weren't specifically being agreed to as part of the settlements. And so there was certainly an effort, therefore, to try to make sure that when these suits were settled, and candidly, most of them did need to be settled because there was no legal defense, and in the absence of that, you could have a district court judge imposing the really draconian deadlines that exist in the statute, and so that to try to obtain deadlines that would allow the chance for public participation. So that was really the approach taken by the last administration to try to address that in the absence of statutory changes, which are what is really critically needed to affect this problem going forward.
Well, let me ask the panelists, and all of you are welcome to comment. I'll start with Kathleen. Do you feel like there's a double standard when property rights groups sue the federal government? They're litigating at full steam, but when environmentalists sue the federal government sort of half-heartedly defends the case or is more willing to settle, or there's something else going on in the background where the environmentalist group has a leg up in litigation. What are your thoughts on that?
I don't know if that I can speak specifically to property rights cases because I haven't been involved in those. My cases involve defending valid existing lease rights, which I realize are a property right, but they're a little bit different. I want to pick up on something Jonathan just said, and that is that predetermined outcome is really what's going on. It is much easier to, and this also gets to your point a bit, Will, which is it's easier for the careerist or the agency to just go along and list than it is to go through the hard work of showing why a listing is not justified. Because if they don't list, they know that there's going to be follow-on lawsuits from that decision by the environmental groups. And there's not as much pushback from the other side suing when a listing is made that is not fully supported by science. So it's easier to just go along and list, put it on the list. It then becomes a burden of the agency without the proper funds and everything. It's also extremely difficult to get something delisted. It's almost impossible to get something delisted. The amount of effort required. So we have an example of the hookless cactus in the Uinta Basin of Utah. So northeastern Utah, it's a major production basin in the West. And it's got a legitimate endangered species. Well, maybe not anymore. But it's, it was a legitimate endangered species listed back in early 90s. And its recovery plan was to have, and don't quote me exactly on the numbers because I'm just pulling this off the top of my head, but it was on the range of, we need to get to 60,000, or it was 20 to 60,000 species before it would be considered recovered. Well, surveys have been done over the decades that show 200,000 species, so well past the goal of the recovery plan. But it's not like the agency's just going to go, hey, great, we've got all this information showing that we've made that recovery plan and we can now remove it. The amount of time, effort, and money that would have to be spent by industry or the state of Utah to get that removed has been prohibitive to date. And that species remains officially unrecovered. And what that means is all the restrictions for the hookless cactus remain in place and dampen development in the basin as a result.
I'm going to turn it over to Kent in a second. Before I do, just a reminder that the Q&A box is open. We will be taking questions in a few minutes, and we want to hear from the public and the voices online about what questions they have for our panelists. Kent, let me throw it over to you in terms of double standard issue and whether you think that property rights interests or any natural resources ownership interests faces higher burdens than environmentalist groups for the government or before court.
Two observations there. I vividly remember testifying before a House committee during the Obama administration on these issues and bills that were introduced to try to address some of the perverse incentives for litigation. And I remember the administration witness testifying that those bills, even acknowledging that they would decrease the litigation burden on the agency significantly, somehow managed to say that they thought it would not affect the budget of the agency. So to me, between the lines, there's a strong sympathy and an undercurrent for sue and settle litigation like this. And I recall a case we brought working with Kathleen. We had a Freedom of Information Act dispute. And there was no question the agency stonewalled us. There was no question that we met all the requirements for attorney fees under the FOIA, under the federal act. And, in the end, did we get attorney fees? No. But I tend to think that if we were Center for Biological Diversity, it would have been an open and shut case, and we'd walk away with our attorney fees, and we'd be perfectly happy about it. And, just for a little perspective here, Will, at Mountain States Legal Foundation, you're one of 5 lawyers. I'm in a firm with 4 lawyers. And Wild Earth Guardians has 10 lawyers on staff. I figured I'd go look at Center for Biological Diversity. It took me about 10 minutes to scroll through the hundreds of staffers to count, 56 lawyers, 6 paralegals, and 1 legal fellow. So they're clearly onto something here.
Well, Jonathan, I want to hear from you. I will note that none of Mountain States Legal Foundation's cases were part of a collusive settlement during your tenure. I'm curious what you think about this question, because obviously you came in having taken over the reins from a Democratic administration and then litigated a lot of these cases yourself. Is there a double standard?
I think there is a double standard, and there's a double standard because there are different standards, is the reality of it. And not in terms of how the Department of Justice handles the cases or defends the cases or the agencies, at least not during our time and tenure there. But the reality is that in the case law and in the statute, there are different standards. And that evolved many, many years ago. And it's baked into case law. It's baked into the attitude of judges when they're viewing these things. I actually testified before Congress at one point during my time with the Department of Justice about attorneys' fees, recoveries, and the various provisions before. And one of the things that we talked about and documented there was the fact that the case law has evolved in an asymmetric way and is not applied to environmental groups in the same way that it is applied facially in the case law to the government especially. And I think it's less in case law so much as inclination of particular of the individual judges that I do think that I've observed. I've never tried to document this, but I do think that there is a correlation between the nature of the public interest organization and its likelihood of getting a recovery.
Well, let me stick with you, Jonathan. You mentioned that the Environmental Natural Resources Division looked like it was pulling back on these settlement agreements that involve payments to third parties. That and anything else that's really surprised you, or not surprised you in the sense that you didn't think they would do it, but that you find particularly objectionable that has been done in the first month or so of the administration?
Well, I do think that the third-party payments action is a very significant one, and it's not one that they have completed yet. The Justice Department regulations were changed after a notice in the Federal Register to prohibit the use of third-party payments in settlements broadly across the division, or excuse me, across the department, as well as specifically as it relates to what are called supplemental environmental projects, or SEPs, which proliferate in the environment and pollution control cases brought by the Environment and Natural Resources Division on behalf of EPA. And so, I think that is a good government type reform, but I also think it's one that when you look at the statutes that are involved and you look at the history, I think it's one that there are real problems, legal problems, challenges to trying to move back to a regime that were highlighted by the last administration, by our administration, as we did those repeals. And it'll be interesting to me to see if others pick up on those legal threads and those legal problems which have been highlighted in objections to the continued use of these types of settlements going forward. Where the problem is that it's not compensation that is going to the victims of particular crimes or environmental violations, but where you are utilizing the existence of a settlement vehicle and a defendant who's creating a pool of money to then have that money paid off to other groups, interest groups, other individuals who are not directly impacted and harmed by an environmental violation. And that's obviously a circumvention of the Congress and its authority under the ability to appropriate funds.
Thanks for that. Kent, do you want to weigh in on what has been particularly objectionable to you over the course of the last 6 weeks in terms of specifics?
I think the executive orders, like Jonathan mentioned, are really noteworthy in their scope and breadth. And it seems like a day doesn't go by that you don't hear about a new administration initiative that shakes me to my core, particularly in regards to climate change.
Kathleen, I think I know what your number one answer is going to be, but what are the sorts of things you've seen that are objectionable to you over the last 6 weeks?
Well, yeah, I mean, the leasing ban, we're suing on that. I fully expect to win in court on that. It's just so clear. The Mineral Leasing Act says quarterly lease sales shall be held. So we've got the plain language of the law. You see Nada Culver and others, John Leshy, I think, has made this argument as well. Former and now current Obama, Biden political appointees that, using this broad interpretation of NEPA and FLPMA, Federal Land Policy and Management Act, we are going to benight and that's with a K, the BLM with authority to regulate air quality and judge on climate change, because we've got this grand interpretation of how NEPA can be used to force them to regulate air quality and climate change. And I think that just bumps up smack dab against the plain language of the Mineral Leasing Act. But I'd like to throw in another wrinkle that even short circuits the sue and settle. Like, it's even more efficient, and I think we're going to see more of this. And that is, you choose which judge you want. So we all know about venue shopping. That's been going on for years. But we've got a certain Judge Morris in Montana who is perfectly willing to issue, edicts from the bench. And it doesn't matter if it has anything to do with the District of Montana where he resides. It can be on Keystone in Nebraska or hundreds of millions of dollars worth of leases in Wyoming. He's going to rule on things that have nothing to do with his jurisdiction, and it's going to apply nationwide. And I think he's pushing it, and he's going to get the Supreme Court looking at this again, going, a district court, really? Ruling on regulations that really should go to the DC Circuit and issuing rulings that are affecting nationwide. I think he's pushing the boundary there. And I'd like to highlight just one thing that he did, which was the Trump administration finished the science transparency rule out of EPA. The Enviros immediately sued on it. And in between the change of administrations, I think it was, like right before Inauguration Day, or maybe it was a little bit before then, he basically said that rule was unlawful, got rid of it like that because no groups had intervened. And of course, the Department of Justice was on the way out. The new one was on the way in. Nobody picked it up. So it wasn't appealed. There's no appeal, no interveners. And that rule is gone with nothing that can be done. They didn't even have to sue and settle with the new administration. They got an activist judge to erase it like that quickly. And that judge is so activist that I think they're going to try that short circuit. So, I think it's even worse than sue and settle in some ways.
Sue and it be over, right? There's no need for a settlement in that.
Yeah, right. Like who needs to settle with anyone when you got the judge perfectly willing to do it himself?
No. Jonathan, you did raise a question in my mind when you were mentioning the Administrative Procedures Act and all the executive orders. How is it possible that the Trump administration executive orders can go through multiple rounds of process and review and be backed by memos and still be struck down by the Supreme Court, whereas the Biden administration was able to issue 40 executive orders in its first month? Isn't there something discordant about the fact that on the one hand, Trump administration orders are struck down despite the process, and yet we have a lot of executive orders that presumably weren't all drafted with the same level of review.
Well, I think that you have to look beyond the numbers to understand that. Certainly, you see a lot of problems along the line of what Kathleen was referring to, of parties forum shopping to particular venues, even potentially particular judges, to attack actions that then make it very, very difficult for there to be an extensive review, a robust review of the record on both sides. Now, with respect to a lot of the executive orders that were issued by President Biden, I think time is going to tell. In part, one of the reasons why some of the early Trump administration executive orders were struck down so quickly was that they were having there was at least a perception of widespread impact on various people's direct lives, and certainly the Mural Leasing Act action has a direct impact on Kathleen's clients, and that has provided a good vehicle for her and her clients to go in and challenge that. But I think we have to wait at some level for the ornamentals of the executive order to then show themselves in more concrete final agency actions before we begin to see these things attacked and struck down. Many of President Trump's actual executive orders were not struck down or invalidated, and many of them were on the books, and a lot of the 40 or whatever the number is was merely the Biden administration taking down executive orders of President Trump that continued to be on the books. So I think really time will tell as to, of those that are not simply rewriting what was already done and actually had a concrete effect on real Americans and their lives and livelihood, how many of those end up being sustained over the longer term.
Okay. Well, 4 years is a long time. We're about 6 weeks in. I want to ask all of you, and I'm going to start with Kent. What are you most worried about? Obviously, there are today's worries, but what are you trepidatious of for the next 4 years? How bad things are going to be? Kent?
I think my greatest fears again center around what the administration will impose upon all of us, industry, agriculture, you name it, in the name of climate change. I almost see this as a fundamental shift in the perceived role of government. Rather than a government designed to serve, it's as if they're serving their higher power of climate change and the planet. And no longer is the role of government to represent the people and the interests of the people, but rather those in office now know better than us. They're going to make the decisions for us, and they're going to erode our Western way of life. And I'm just nervous about the continual chipping away in that regard, and higher costs and what it'll do to our economy.
One note, we do have some questions. If you have questions, please feel free to add them to our Q&A box on the bottom of the screen. We will be going to questions in a moment. Kathleen, let me throw it to you. Without giving a roadmap to what the Biden administration may do over the next 4 years, what are you most worried about?
I guess I hear Kent and I get a little worried, but I fundamentally think that it's just the pendulum swinging, right? And I feel this is another round of what we saw during the Obama administration. Oil and natural gas was roadkill in the rearview mirror. We were going to have all renewables 10 years, after the start, after the start of when Obama started to calm the seas, right? And the water started to reside. So obviously that didn't happen because people actually use oil and natural gas and need actual 24/7 energy, just like we just observed in Texas. Intermittent sources can't do everything for us. So reality will set in. Then it was, those shovel-worthy projects, and we were going to create all these green jobs. Now we're talking net zero. That's the buzzword. And all this is going to be, we're all going to be electrified, and the internal combustion engine is going to go away by 2035. It's the same promises made by politicians who will be well out of office before those chickens come to roost and we don't get, we're not all driving around in electrical vehicles by 2035. Forget that they have a higher climate change impact than actually oil and natural gas does. Forget that. But so I just see this as another round of the same. We've got a sharply divided Congress, so most of their policies aren't going to make it through Congress anyway. We need more people doing what Texas and Western Energy Alliance is doing, which is suing on these executive orders, just like, there was a barrage of lawsuits against anything the Trump administration does. So the other side needs to do the same now. And I agree with Jonathan, some of it is not ripe just yet, and time will tell. But, that's going to play out. The courts are going to play out. Those however many judges, federal judges, 250 or whatever it was that Trump got in from the Supreme Court on down, are going to be very effective at reining in some of this. So I fundamentally think the checks and balances will play out. And then you're going to have things like Texas and COVID, where people go, oh, wait, the Green New Deal means I really can't drive my car and heat my home. That's not, you got the 2022 election. That's not going to play really well. So.
No. Jonathan, what are you most worried about over the next 4 years?
I would say one of my larger concerns is certainly in the energy space, that a appropriate mix and balance of will not continue to be the watchword of how we're going to go about generating energy. And that there's certainly, I think, valuing renewable energy, and a lot of good work is being done by a lot of people. But at the same time, as our experience in Texas just showed, that it is important to have certain baseload forms of electricity to ensure resilience over time. I'm concerned about reflexive backlash against natural gas because it is a fossil fuel when it is a dense energy, a form of energy, and burns very clean. And there are transportation constraints that exist, and the seeming battle against pipelines means that this energy dense and clean burning form of energy, that there are going to be constraints on that as well, just as there are electricity constraints in the network. And so, I do have very significant concerns that, as a matter of energy policy, that there will not be a sufficient effort made to look at the balance of needs that exist if the United States is going to be a country in the world where the lights never go out. And we've now seen in the last several years, California brownouts. We saw what just happened in Texas. And I think that we will continue to stumble into problems if we are not going to take a balanced approach and view of where our energy is coming from. And energy is fundamental to everything in the modern economy. Everything we buy, everything we do, there's some degree to more or less of energy that's baked into the price of that. And I think it's very important to our public policy and going forward that people continue to recognize the need for balance.
Thank you. All right, well, we're going to move into questions. As a reminder, the Q&A box in the bottom of your screen is open. We do have a few questions, but we probably have time to answer a few more. The first one relates to double standards. And echoing some of the themes that we spoke about, the question is, it seems like anti-deference arguments tend to get more purchase when they're made by environmentalist groups as opposed to the other side. What do the panelists think in response to the idea that originalists and textualists are actually creating weapons by advancing these legal theories that are actually not being applied fairly and they're only benefiting environmentalists in these suits? So boiled down, back to the idea of double standard, is there a problem with perhaps deference doctrines or other court doctrines that just aren't being applied fairly? Jonathan, I think, given your experience, we'll start with you.
Yeah, I mean, I do think that it is a question worth asking about whether there continues to be some place for certain of the deference doctrines. But I think that what the questioner is recognizing is that these tools are not necessarily being equally applied and used. And so in a world where that's the case, are we so confident that a change in the way that the law is applied is going to result in some sea change in the limitation of, for example, the administrative state? One of the reasons why Chevron came about, and for many years Justice Scalia was one of its proponents, was the idea that at least administrative agencies, executive agencies are accountable in some ways. Whereas if you are eliminating deference doctrines and put it more firmly in the view of the judiciary, you're arguably empowering that branch more at the expense of the executive. And it is unquestionably the case that the Chevron Step 1 received a real arm shot in terms of the number of cases where a court found a administrative action unlawful and prohibited by the statute during the Trump administration. I actually had the numbers, and it was remarkable with certain various judges, particularly the DC Circuit. If you compare the number of cases that were decided on the Chevron Step 1 grounds from 2017 to the years that came before it, the numbers at one point we looked at this weren't even close. It was exponential growth in the use and application of Chevron Step 1 to invalidate Trump administration agency actions. So I do think it's a question that is worth asking, and that it's one that academics and people should continue to study.
And or Kathleen, do either of you want to weigh in on the topic of deference or double standards?
Just real quick, I think my view would be that the administrative agencies have grown so huge and so powerful and such a difficult ship to steer that the erosion of deference I view as very positive.
We have a question for Kathleen specifically. What will the long-term impact be for Americans if Biden is able to continue to stop new oil and gas leases?
Well, I appreciate that question because it gives me a chance to just do a little flavor on what that is. So it's being characterized characterized as a pause, as a short-term pause. I don't know how many times Congresswoman Holland said that during her confirmation hearing for Interior Secretary. It's just a pause, it's just a pause. Well, if you read the plain language of that executive order, it's to do a comprehensive review of the impacts of leasing and permitting, and including climate change. So I don't know that the department has ever done a comprehensive review, which is a programmatic EIS or environmental impact statement. I don't know when they've done one of those in less than 4 years. So it is a Biden ban. It is a leasing ban for the entirety of the Biden administration, at least the first term. And it is meant to then find ways to curtail further oil and gas leasing and permitting. So it applies to new leases right now, but the intention of that EIS is that it will apply to permitting as well. And I don't think they'll go so far as to, okay, they're going towards a net zero, right? But I don't think they'll get to a point where, it's got to be net zero, and so we're going to stop all permitting and leasing. But it is going to be so constrained that, for all intent and purposes, that it will be almost impossible to operate on federal lands. But let me talk about the impacts of this new leasing ban. I mean, so the rhetoric is that, it's just new leases. Industry already has enough leases. You just go about your business and develop on those existing leases now. And, it shouldn't be a problem. It's not affecting existing leases. Well, it's going to affect existing leases in two major ways, because the federal land ownership is complicated, and it interlocks with Indian, tribal, state, private lands, is that if you're lateral, so we're drilling horizontal wells where we go a mile down and 1 to 2 miles out. It is very difficult in the Powder River Basin of Wyoming or in North Dakota in the Williston to shoot that lateral out and not hit a patch of federal minerals or land. And so once you do, you get sucked into the full process. And so you might need a new lease to develop that private well that sits on private lands. So it will hold up existing development right away. It's starting to affect it now. And then the other situation that is also very common is that, unlike those who are now in the Interior Department, we don't have a centrally, and despite their wishes, we don't have a centrally planned economy. So, if Acme Oil and Gas has all the leases it needs, great, they're good, they can continue. But XYZ Oil and Gas Corporation might not have all the leases it needs because it takes a long time to get your lease. Even, there's process. So that company may be waiting. And so if they can't get all their leases to develop their federal unit so that they can develop their tribal and their Indian Alati and their private minerals all together with the federal minerals in that unit, then it holds up that existing project as well. So it's not just about existing leases. It very quickly impacts existing leases as well. And I see this as a long-term, and that's why we're calling it the Biden ban. And that's why we sued immediately, because we need to get new leases going forward.
And Kathleen, maybe follow that up with a study out of Wyoming on the economic impacts.
Yeah, we're seeing a lot of voices piping up across the West. I mean, a third of New Mexico's budget comes from oil and gas on federal lands, for example. The University of Wyoming professor did a study for the Wyoming Energy Authority, and it found that a Biden ban for just 4 years, just on new leases, will impact $33.5 billion in GDP across the West. It will kill 58,700 jobs annually in the West by the 4th year of the Biden term. And it will take away about $8.3 billion from state, local coffers, so that there will be less money for things like COVID response and education and all the things that, so it's not just affecting workers in the oil and gas industry, it is affecting the entire West.
We have another question for any one of the panelists who wants to weigh in. It's about the Paris Climate Accord. What impact could international climate treaties have on the United States, the Western United States, or any other part of the country? Will federal agencies now be able to base their administrative decisions on international agreements like this? any one of the three of you that wants to weigh in on that.
So they should not be able to, in the absence of the treaty, of it being treated as a treaty or otherwise being enacted by Congress through enabling legislation to give it domestic effect. So it will nevertheless likely have an effect, or could have an effect, by serving as a basis, a rationale, reasoning for the actions that federal agencies take, which may constrain in certain ways and be used to justify actions, and to whether it be the leasing ban or other ways of constraining currently available forms and sources of energy, and again used in a way to make those decisions, they would say, not arbitrary and capricious. So I do think it can have domestic impacts, but it shouldn't come merely from the entering into the agreement in and of itself.
Thank you for that. Well, apparently my question about what are you worried about in the next 4 years may have struck too cynical of a note, because our next question is about what you're optimistic about over the next 4 years. And actually, I think this is a good way of closing us out. So to each of the panelists, I think we'll start with Kent. What are you optimistic about over the next 4 years?
Well, I'm optimistic that American ingenuity, hard work, is going to continue to drive our economy, our way of life. We've been through good times, we've been through bad times. The American public is resilient, and I don't think they're going to put up with a lot of the aggressive agenda that we're seeing currently.
Kathleen?
Yeah, I was starting to seem like the optimist on the panel based on that earlier question. Totally agree with Kent. I'm very optimistic that like I said earlier about the pendulum swing, with all of the judges that Trump appointed, we have some really good, we have some really good judges who I think are looking for ways to pare back the administrative state. And I think the push, that the overreach that we'll see from the Green New Dealers and, the Biden administration, because it's inevitable, even though they have a razor thin margin in Congress, they're going to, and that's why they're going so quickly, because they know how razor thin it is. Joe Manchin can change what happens, with a press release. So I'm really optimistic that we're going to see some fruit and some fruit bearing from that, and that we're going to get some good precedents set that could help us to, rein in some of the overregulation that kills American ingenuity and hard work and all those good things that Kent just talked about.
Jonathan, just a few seconds on your optimism in the next 4 years.
Yeah, I would sound a similar note as Kent and Kathleen. And, I'm optimistic about the rule of law and its capacity to rein in excesses if and should and where they will occur, and of the ability of those who are affected and regulated by these things to turn to the courts, to turn to the standards. And yes, there are some venues where you're more likely to get judges who may tend to be more results-oriented posture than in other places. But on the whole, I'm optimistic about the capacity of our legal system and the great lawyers, some of whom are participating in this call and the panel and what have you, to help to ensure that the rule of law is respected and implemented over the next 4 years by the courts, even if we won't necessarily expect the actions of the agencies to be what we would hope for.
Well, I'm optimistic about the next 4 years for Mountain States Legal Foundation and being able to represent our clients and fight back against intrusions on property rights. I want to thank all of our panelists today, Kathleen Sgamma, Kent Holsinger, and Jonathan Brightbill. What a truly enlightening and informative panel. It's been terrific. We are very honored to have all three of you. If you are watching this and you want to get involved, either you want to get updates or you want to review our cases, you can go to mslegal.org and check out our website. We have mailing lists, we have information. We would love for you to get involved and get active over the next several years. We're going to need your help in order to fight the fight and be there throughout the rest of the Biden administration. And we look forward to seeing you next time. Thank you so much for participating in this webinar, and we can't wait to do it again and look forward to having our panelists at a future event where we can continue to hear their insight and terrific content. Thank you, everyone.